bowel, sexual function, and pregnancy postpartum. These issues can affect both women and men and include urinary frequency, urgency and incontinence, pelvic pain, constipation, IBS, menopause, painful periods, and more. Call 724-437-0556 for an appointment in Uniontown. Personalize your care with NovaCare.
It's a new year and a great time to save at Autoland on a new Hyundai. All of the quality that lets them offer America's best warranty, Hyundai Owner Assurance, with 10-year, 100,000-mile limited powertrain protection, 5-year, 60,000-mile bumper-to-bumper protection, unlimited roadside assistance, plus 3-year, 36,000-mile free complimentary maintenance. Autoland still has a great selection of new vehicles at pre-tariff prices, so stop in and check them out. Plus, there are a lot more reasons to buy your Hyundai at Autoland. Voted Best in Fayette Import Dealership and also a Best in Fayette New Car Dealership. Conveniently located and family-owned, they have served the area for over 60 years, and you will deal with friendly hometown salespeople, along with Hyundai's award-winning service department, who will continue to take care of you and your Hyundai. Autoland Hyundai in downtown Uniontown. Visit their website at AutolandHyundai.com, and as Chris Jr. says, you will always pay less to drive the best at Autoland Hyundai.
Stays compass. I got no direction now. I'm gonna find my way somehow. Barely on this tightrope. I'm stuck in between the here and now, and I'm trying to figure out.
And it's now time for a couple of things with Wendy and Josh as we welcome Wendy O'Brien from Proden and O'Brien Law Firm, and also Josh Kryzak here from WMBS. Guys, take it away.
Thanks, TJ.
Thanks, TJ. Wendy, I feel like I haven't seen you in forever.
I miss you.
I know, I miss you too.
It's been like a couple months.
It has, because we did a fun Thanksgiving episode.
Yes, we did.
We talked about frozen turkey bowling and all kinds of good stuff.
Yes.
Out of control balloons.
Yes.
And then we missed out on a Christmas episode.
Yeah.
So
the holidays are nuts, aren't they?
They are nuts.
I feel like they just creep up on you so quick, and then time is so short. And
yeah.
Yeah, we had to miss last month. But
yeah.
Let's make it up today.
I think we will. Full disclosure to everybody, our new WMBS intern, Haley Bill, is sitting in studio as well. So if you hear her chime in, that's her off camera. Thank you for joining us, Haley. And just so we go remind everybody what we do here. So a couple of things with Wendy and Josh. This is not legal advice.
No, not
This is
at
a
all.
legal talk show where we kind of throw back and forth some things that you might get into and give you some ideas and some directive, but it's not advice.
Yeah, we want to educate you. We want to empower you. We want to give you some examples of things, but in no way is this meant to apply to your specific issue.
Correct.
Your specific case. You should always consult an attorney if you're having criminal issues, especially. That's what we're going to talk about today.
Absolutely. And before we do that, if they have to consult an attorney and they're looking for one, I know a good one.
Give us a call.
There it is. Proden and O'Brien.
Proden and O'Brien. We are located just 2 doors up from the courthouse on Main Street. There's 3 attorneys there in the office. My partner, Jeff Proden, he handles a ton of business matters, real estate matters, corporate matters, civil litigation, and we also have an associate, Sean Lematowski, who handles a little bit of everything.
Yes.
And I do a lot of estate work, family law work, and criminal law work. We're going to talk about today.
Yeah, and so and again, as Wendy often does, she creates these beautiful breakdowns of what we're going to get into, but the title of today's is What TV Gets Wrong About Criminal Law in Pennsylvania and Why It Matters.
Yeah, so as our listeners know, we are true crime junkies.
We are. We love true crime.
Yes. and I can tell you that without a doubt, it sort of presents its own stigmatism in the law, and people think they know, from watching television what the law really is and what it should be here in our county. I for 8 years I worked in the DA's office, and I used to start out my criminal trials when I would talk to the jurors, telling them this is not CSI, this is not Law and Order, this is real life.
Yeah.
These are real people. We don't interview characters. These are real police officers, real evidence. So you got to look at it differently.
Yeah.
Because,
it's not all going to be right. It's not all going to be ducks in a row. It's not all going to
No.
make perfect sense.
No, definitely
The science isn't always perfect either, but
Correct, yeah.
but you do use it.
Yeah.
The science is used here. DNA evidence can be used. All those things can
Absolutely.
happen here.
Sure.
But it's never as clean and easy in 1 hour package like you get on TV.
Correct. Yeah. Yeah. So we just want to break down maybe what a criminal case looks like from start to beginning and talk about some of your rights. And ultimately, at the end of the day, I hope that we teach you how to exercise those rights if you ever need to.
That's right. I've learned from Wendy in the 8 months or so, 9 months that we've been doing the show. We're already like at 9 months,
Yeah,
I think.
so.
Yeah.
I think so.
So yeah, I've learned a lot from her, and every single week every single month there's some new nuggets. So we hope that you tune in and find it informative. So talk to me about what we're doing today.
All right. So let's talk about a typical criminal case. Everybody hears and has heard the word Miranda warnings, right?
Right.
You've heard that,
Sure.
correct? So what exactly are the Miranda warnings? When are they necessary?
Yes.
So, in essence, and one of the things that have really lately have driven me crazy with criminal prosecutions are the way people don't shut their mouths.
Okay. So they should take that seriously.
Yes.
Yeah.
You actually do have a right to remain silent. But you need to know when the police can question you without giving you Miranda warnings, and when they don't. They're not allowed to question you
Right.
without Miranda warnings. So there's a difference.
Yeah, so walk us through it. I've been arrested or I'm facing criminal charges. When does that start?
Okay, so there's different scenarios.
Okay.
We can go through them.
Yeah.
But ultimately, let's say you're sitting there and a police officer is questioning you for some reason.
Right, and I don't know. Maybe I haven't been arrested.
Yeah, you don't necessarily have to be arrested.
Okay,
Sometimes
okay.
they knock on your door and have some questions for you.
Right.
And a lot of people think that if I cooperate, I'm not going to get in trouble.
Okay.
Right.
Right.
But I can't tell you how many times that cooperation ends up leading to criminal charges, even though maybe you didn't think you did anything wrong.
Yes.
Actually, and we can go into more detail about that. But so if you are faced with a police officer questioning you, you
Yes.
need to determine, number one, am I free to leave? Am I free to leave and just get away and walk away?
You can ask that question.
Absolutely. That is a 100% fair question to ask the police. You're not being rude. You have rights, and you're exercising your rights, and you want to know, number
Okay.
one, do I have a right to leave?
Right.
And they'll tell you, yeah, you're free to leave. And they'll probably end up saying something like, but we'd really like you to stay.
Right.
Because if you answer these questions, you probably won't get in trouble. Something like that. They have a good way of spinning it.
Sure.
And they're doing their job. I'm not
Right,
trying to
and
put
we
them
know
down.
that
Yeah,
you're
absolutely.
pro police. You know how
Uh-huh.
great you have great relationship with
do.
them, but you're also protecting the rights of clients.
Correct.
Yeah.
So at any point, if the police tell you do not have to stay and talk to them, you do not have to stay and talk to them.
Right.
So you can get up and you can leave.
Right.
You don't have to answer their questions.
Okay.
Now, there's some circumstances where the police have a right to do some investigation work without giving you Miranda warnings. So, for example, if they're conducting a traffic stop and they pull you over and they say something like, "Where are you going? Where are you coming from? Have you had anything to drink?" You don't need to have a Miranda warning before that.
You're compelled to answer those
You
questions.
can answer this question. Now,
Yeah.
you say compelled. You're not actually compelled.
Okay.
You don't have to answer. You can just
But
say,
don't you run a risk at that point then of
"Oh, they're pulling you out of the car."
yeah,
They're-
you're going to cause if you really haven't done anything and you don't answer the simple questions like that, you are running the risk of making it into a bigger deal
Yeah.
potentially.
Correct. Yeah.
Yeah.
And you're actually at a traffic stop. This is one of the things you're not really free to leave typically.
Okay.
They want to run your license plate. They want to run your driver's license.
Do they have is it required to run the driver's license? If they ask you for it, do you have to give it?
Yes, you should give it to them.
Okay.
Yes.
Just trying to, I'm going through some other
Absolutely.
things too.
Yes.
Yeah. Okay.
No, because they're doing an investigative stop for some reason.
Okay.
And they should have had reason to stop you.
Right.
Whether it was, your registration is off, whatever the case may be.
You did something, you ran a stop sign, whatever.
Yeah, you need to give them your driver's license. Now, if you choose not to, they're probably going to arrest you.
Yeah.
And then you're going to be in custody.
Yes.
And then they'll get a warrant for that
Right.
information.
Okay.
So,
okay.
You need to cooperate. You should always cooperate. If you have nothing to hide, you should always cooperate. However, there's a difference between cooperating, Josh, and being subject to a severe investigation.
Okay.
You don't need to get to that point.
Right.
Okay, so Miranda warnings require, there's two situations. First, you are not permitted to leave.
Okay.
And they're going to interrogate you. That's when you are required to have your Miranda warnings given to you.
Okay, so if they say you're not permitted to leave, that's when they have to do the Miranda warnings?
Yeah, and they're going to question you.
Okay.
Correct.
Okay.
So if they're not going to question you and they're just going to hold you in a cell, they don't have to give you Miranda warnings.
Right.
But if they're going to pull you out and question you about something, they have to give you Miranda warnings.
So technically, if they had you in custody and left you in a cell, they could do it for some period of time before they ask you questions. But if they do come to ask you questions, that's when that
they
applies.
have to give you Miranda warnings.
Okay.
And that's when you have the right to stop questioning altogether and ask for an attorney. And you should do that.
Yes.
You should do that. And let me explain why. These individuals, these police officers are trained to question you.
Yes.
They are trained. And they can go on for hours and hours and hours questioning you. And if they wear out, there's someone else in the back that can come pick it up and start questioning.
Yeah.
And they're usually always recorded and video recorded. So there's probably somebody watching, and they're probably feeding questions to the person actually questioning you.
Okay.
So you're never going to wear out an officer.
Yes.
You're not. They're just highly trained. So you should always have an attorney with you if you are in a situation where you are in custody and you are being interrogated.
Okay.
It's your right to have an attorney
So
present.
why not do it?
Correct.
That's a legal expert that you then have on your side. So.
Yes, 100%.
Now, I will say one of the arguments that you hear from people, and this I want to get your take on this. They say, "Well, I know I didn't do anything wrong, so why not just answer them?"
And that's mostly why people do answer the questions.
Yeah.
But you and I, being true crime junkies, we've seen these interviews where they start out very innocent.
Yes.
And people end up admitting to something
that they may not have even done.
We've
learned that from true crime too.
Correct.
It's a real thing that happens.
Yes. They have a way of, convincing you
that maybe you did do it.
That you did something wrong.
Yeah.
We ask this question often in jury, like when we do jury selection. If a police officer told you that you were speeding, and you weren't speeding because you looked at your speedometer.
Right.
And you were within the speed limit because you always follow the speed limit. But the police officer told you were speeding. Would you believe the police officer?
Yeah. That's a really good jury question.
Do you know how many jurors say they would?
Yeah, that's...
Even though they know for a fact they were not speeding.
And Haley Bill just said that she would.
I would.
Yeah.
I'd be like, okay.
Because you doubt yourself because it's somebody that you trust.
Yeah.
And you should trust, but that's why you should always have an attorney.
Yeah.
Because there's situations where the police can convince you did something that you did not actually do.
See, now, if I was on your jury pool and you asked that question, I would say yes because I was speeding.
Well,
Don't come for me. Don't come for me.
Speeding, so. No, but if you know for a fact you did.
Yeah,
not
I got you. I got you.
So
it's crazy though that it is. I think it has to do with that level of trust. It's just like teachers or anybody in those powers. They have some authority over you. You trust their judgment, even if you shouldn't.
Well, and police officers, God bless them. They're wonderful. They do such a good job. But they do a lot to gain your trust, too, during these interviews.
Sure.
I've watched many, many, many interviews.
Yes.
And they tell you the whole way through, it's okay. I'm on your side.
Yes.
But let's talk about this. I understand. I know where you're coming from. They'll use first names. They'll reference your mom if they know your relatives.
Yes.
I mean, here locally, our Uniontown City
may know you.
officers, they know your family. They know where you live. They know your aunts and uncles and all your problems. And they'll use that to gain your trust to get you to open up.
Right. And you probably have a lot more examples than me. But back when I was a reporter, I was a crime reporter for 8 years. I got to do a lot of really fun stuff. Did some ride-alongs.
Yeah.
And I got to sit in a couple interrogations. And one in particular stands out to me where the police investigator, who was a friend of mine, and I trust him and he did a great great job. He very much got this person to believe that he was their friend and then got the person to admit to it. Now, whether that's true or not, I have no idea. It wasn't for me to decide, but I watched him use the tactics that you're talking about.
They're trained to do that.
Yeah.
So there's no reason you can't still give the information you have.
Yeah.
Once your attorney is present.
Right.
Because an attorney can control the situation
Right.
for you. They can control the narrative. They can help control that leading question aspect of a police interrogation.
Right.
Yeah, I mean, I've sat in on police interviews with clients. I've sat in as an ADA. I have, watched many of them. It does not hurt to have an attorney present. And all you're doing is, are they going to get mad at you? They're going to pretend to be mad at you.
Yeah.
Well, if you have nothing to hide, why don't you just talk to us?
Right.
But as soon as you say that, they can't ask you any more questions.
Right.
You have to get your attorney present.
So if they would ask you questions after that, then they're violating the law.
They are. Yeah, and it's actually, I've seen that happen where the questions continue and the court will usually, I'm not going to say every case, but the court should throw those answers out.
After that point.
Correct.
So if you ask for an attorney, you're shutting it down.
Yes.
Okay.
Now,
that's really interesting.
You can also rehabilitate it, because I've seen also interviews where somebody says, I better get an attorney, and they stop the questioning, but the trooper or the officer is still sitting in the room with them waiting for the attorney, purportedly, and they just decide, well, I could tell you this, and I could say this, and I could, and then it's
you open that up for potentially allowing that in.
They have to go through the Miranda again with you and make sure you understand. Like, you can talk, but you just asked for an attorney, and now you're saying you don't want an attorney?
Yeah.
I need to know for sure you don't want an attorney.
Right. And for those folks out there who maybe don't know the term Miranda warning, it is essentially the warning that you have the right to an attorney.
You have a right to remain silent.
Yeah. You have the right to not tell us stuff and to get an attorney.
And anything you say can and will be used against you in a court of law.
Right.
And you're being recorded, most likely. You're being video recorded, most likely. And they are writing down everything you say.
Yeah.
So
whatever you're saying, and again, even if you have nothing to hide, but you find yourself in that uncomfortable position of having to answer police interrogation or questions, it might be a smart decision to ask for an attorney.
Yeah, for those people that say, well, what would it hurt if I have nothing to hide?
Right.
Well, what would it hurt if you have nothing to hide and you had an attorney present?
Right. Just to keep you from getting tripped up or getting stuck or stumbling or not being sure, because as the questioning continues, sometimes you might not be sure of where you're headed or what you're saying.
Yeah, you never know what door you're opening. Or, there's a possibility of incriminating somebody else who you don't want to incriminate.
Yeah.
And it could be unbeknownst to you.
Yeah.
For some reason. So.
Absolutely. No, I think that's all really interesting stuff. So where are we headed next?
Well, I guess a takeaway from Miranda's is, yes, in Pennsylvania you have a right to silence, and it is your right, but only if you actually stay silent. You have to use that right.
Right.
If you talk, it's you open that door.
Right. So what about, let me ask you this. So if police are just showing up on a scene, they ask you some questions, I don't think that this necessarily would apply to this. They're trying to find a suspect. They're chasing somebody. Did he go that way? You can say, I think I saw someone go that way.
Yeah.
I mean, you still want to cooperate
Absolutely.
too, especially with those things that regarding public safety, that kind of stuff.
Yeah.
So it's not necessarily in every case does it make sense.
No, if you get a phone call and the police want you to come down to the barracks and give a statement, that's when you say, all right, let me get my attorney.
Okay.
But if they knock on your door and just, hey, do you have Ring doorbell footage? We had a crime across the street. We just want to look.
Yeah.
I think that's okay.
Yeah. Okay.
Yeah, I mean, you're going to have to use your judgment.
Right, just with anything.
If you are in any way not free to leave with the police, then question what's coming out of your mouth.
Okay.
And talk to an attorney.
Yeah. So if you're just joining us, it's a couple of things with Wendy and Josh on WMBS. I'm Josh Krysak. She's Wendy O'Brien. She's with Proden and O'Brien. And if people want to get in touch with you, Wendy.
Yeah, give us a call. Our phone number is 724-437-3484. We're 2 buildings before the courthouse on Main Street, 99 East Main. You can stop in. We also have a website, prodenlaw.com. email addresses, Facebook page. You can find us everywhere.
Yeah, and we've had some people actually get in touch with you via Facebook. So thank you for doing that.
Yeah,
That's a way to find her.
And just as another statement, if there's something you guys want to hear about that we don't talk about on the show, maybe for a future show, don't hesitate to comment under our video and let us know what some of your ideas are.
What your interesting stuff are. Yeah,
what you'd like to hear about.
Yeah, I mean next month is Valentine's Day. Maybe we'll do some heartfelt stuff. Who knows?
Yeah, there we go. That's good.
I'm just saying.
Yeah, that's good.
Yeah, for sure.
I like it.
So I see the next bullet point here says being charged does not mean you're guilty.
Yeah. So this is, I'm sure everyone has heard, of overzealous charging.
Yes.
Maybe the police actually charge you, but they're really trying to find someone else or get somebody else or, convict somebody else. But they're getting to that person through you. Okay. That's a tactic that's used quite frequently. Okay. For example, maybe a husband is involved in something and they end up charging the wife with a crime with the thought that, well, she will flip on him or he'll plead guilty to everything to get her off the hook. Okay. So I think that there is... when people come to us with criminal charges, they're usually charges that are the max that they possibly could have charged these people, and sometimes beyond. Because at that initial charging and preliminary hearing stage, they don't have to prove their charges beyond a reasonable doubt. Okay, it's a very minor a standard of proof.
So on those same lines, one of the things that you often see too is say an incident occurs, and when it occurs they file 7 charges against somebody, but by the time it gets through everything at the end, they end up pleading or going to trial on maybe 2 of the lesser charges. I think that's probably pretty common. Is that true? And is that because they're not sure how far it's going to go, so they're going to say here's all the things it could be?
Yeah, I think that's a very fair assessment. So in the beginning, you might not even know all the facts. Yeah. So it might turn out to be, not as significant as initially thought. So a good example is aggravated assault charges. So any kind of assault. Mm-hmm. If there is any type of injury, typically the officers will charge an aggravated assault, a simple assault, maybe a recklessly endangering, and also a harassment. Okay. Those are the typical 4 standard charges that you're going to see with some kind of assault, physical bodily injury. But as it plays out, it's very possible that the injuries are not that serious, so they wouldn't rise to the level of aggravated assault. Got it. So that felony charge would most likely go away, and then you're ended up with a misdemeanor and a summary. And
I think too that you would agree that that's not necessarily the police officer trying to trip anybody up or anything like that. It's in the infancy stages. There was something that occurred. Yeah. You're going to start out with what it could be, and even if it ends up being just a harassment charge or something in the end, doesn't mean that there was any nefariousness in as far as the charges that were filed initially.
Not at all. No, not at all. I think that they're gonna overcharge in the beginning because they have to charge all at once. Right.
They have to put them in.
Yeah. Now there are some circumstances where they can come back, like if somebody ends up dying after, a car accident or something with a DUI related, they can then add the homicide aspect to that. But for the most part, they get one chance to charge you. Yes. And so they're going to charge everything, and then you can plea it down from there. Yeah.
So we're talking about if you're charged does not mean you're guilty. I see bail myths in Pennsylvania. Tell me about that.
Yeah.
Because I like the little not equal to side there.
So just because you are put in jail for the night or put in jail, it doesn't mean that automatically means you're guilty of something. Yeah. A lot of times the type of charges that are being held against you is it's what the court looks at as to whether or not to let you out of jail. Mm-hmm. So you may end up going to trial on an aggravated assault case, and you might be found not guilty of that charge, but for the last, year, you've been sitting in jail because the judge doesn't want to let you out because the allegations are so awful.
Yeah, right.
You know what I mean?
Right.
So just because you're in prison or someone is in prison doesn't automatically equate that you're going to be found guilty.
Yeah.
It's the degree of the charge that's holding you there. And it also goes back to your, prior criminal history. That's going to be a part of whether or not the judge gives you a reasonable bail or bond for you to get out, and whether you can afford to pay it, obviously.
Right. Another note here, you have why weak cases still move forward. So can you explain that, what you mean there?
Yeah, I can definitely explain that. So as we talked about initially, the burden of proof at a preliminary hearing is just a probable cause type burden of proof. It's not beyond a reasonable doubt.
Right.
Very low standard.
That was the thing I covered the most. I wasn't the court reporter.
Yeah.
I was a crime reporter. I would cover it from the moment of arrest up through the preliminary hearing, and then it would go to the courts.
Yep.
So.
And so it's a very low burden, and 99% of the time, the allegations and the testimony will be sufficient to meet that low burden. So it's going to move forward.
Right.
That doesn't mean it's going to move forward after a jury trial.
Right.
Jurors have to find you guilty beyond a reasonable doubt. And that's something that's foreign to a lot of people, but that is a very heightened burden.
A high bar to pass.
Very high bar to pass. And it should be, because you have to basically, the Commonwealth has to prove that you did this crime. Well, that's our constitutional right.
Yeah, and it's interesting because, again, it goes back to what we're talking about. You and I are crime junkie people, and I just listened to an entire podcast about a crime that occurred in Ireland, but it involves someone who was murdered from France, and France's justice system finally got involved in it too, and their burden is completely different.
Yeah.
It's completely different, and it involves, how you feel.
Oh, wow.
How you feel about the person.
Oh my God.
Like, it's so subjective. It makes me very happy that we have a lot more regimented.
Absolutely.
Here's what you have to prove.
Yeah, and again, here in Pennsylvania, there are standards, and you have rights as a defendant if you are charged with a crime. And the one way you enforce that right and hold the Commonwealth to the standard is you proceed to trial. You exercise your right to a jury trial.
Right.
And that's often that's what you are unfortunately forced to do, because maybe the evidence isn't that great, but the Commonwealth isn't giving you any kind of offer to plead to that's even reasonable. So you end up proceeding to trial. But it's not hard for a very weak case to move along, because essentially a juror doesn't hear it. It doesn't meet that final test of burden of proof beyond a reasonable doubt until the very last stage. So a lot of cases end up dragging on for, about a year and a half, all things said and done. The Commonwealth has 365 days to bring you to trial after you're charged.
Okay.
But that can be delayed if you start asking for continuances.
So you can extend that yourself.
Yeah, defendants often have to, because they need time to get an attorney, or they need time to review evidence, or their witness isn't available. A lot of those kinds of things.
Yeah.
They file pretrial motions to try to get certain things dismissed, which will delay things.
Yes.
So essentially, though, it's about 1 year from the time you're charged to the time you get your final disposition of a jury trial.
So there's a note here that you have that it jumps out to me. It says pressure to plead even when defenses exist.
Yeah.
So I guess that may tie into what we just talked about sometimes cases, they feel like this is their person, but it's a weak case.
Yeah. So I actually have a good example of this just from this week. I don't know if our listeners are familiar, but we have a criminal jury trial week once a month in Fayette County. And that's all jurors are called in on that Monday morning. All defendants have to report. And these are the people listed. These are the cases expiring next. So the 365-day rule basically is up, and they're coming to trial, and they have to decide. Are you going to trial today, or are you going to take a plea, or what are you going to do? So I do see often that people are put into a position where they feel forced to take a plea.
Yeah.
And it's for one reason or another. It might be they don't feel like their attorney is ready for trial, but they're facing a judge or a courtroom that's saying, well, your case is up, you're going to trial.
Yeah.
Or maybe the DA isn't willing to change the charges at all, or negotiate a plea or anything. So you're basically stuck with what you have.
Yeah.
It happens quite frequently. There's also a case where, maybe like we talked about before, the charges are probably more than they should be. Like an aggravated assault when it should have been, maybe a simple assault, just a misdemeanor charge. But the DA says, nope, we're going to trial and it's going to be aggravated assault. And you feel so, torn, but they're willing to let you plead to the simple assault, but you have to plead right now and not go to trial.
Right.
So you sort of have to you have to weigh that out. Is it worth going to trial, risking getting found guilty of a higher charge?
Right.
Or do I take this other charge, even though I know I'm innocent?
Yes.
And just plead to this.
It puts them in a tough spot.
Get probation. Yeah.
Tough spot.
It's tough, yeah. And a lot of people do plea when they know they're innocent.
Yeah.
Just because the risk of going to trial with this higher charge is so significant for them.
Yeah.
And they will likely face jail time.
Yeah. And this note, too, I really like. It says, in Pennsylvania, charges are easy to file, but convictions are supposed to be hard.
Yeah.
So you want, and that, again, that goes back to the burden of proof. It goes back to protecting all of our rights as citizens. We want those convictions to be challenging and difficult because it would suck if you just put people behind bars without an actual case.
When I was preparing for this and I wrote that, I was curious to see how many cases actually get charged every year.
Yeah.
In Pennsylvania, and how many actually proceed.
She's got stats.
Yeah, I got some stats. How many actually proceed to trial?
Okay.
Just to give our listeners an idea of what we're talking about. So the last statistic available was for 2024.
Okay.
Obviously. And in 2024, in the state of Pennsylvania, this entire state, 124,285 new criminal cases were filed.
Okay.
So that's a lot.
That's a lot.
And these are felonies or misdemeanors.
125,000 is a lot of cases.
Yeah, and not summary offenses. So I'm sure that would raise it quite a bit.
Oh, yeah.
The same year, jury trials that were held in the state of Pennsylvania were 1,439. So that's
Holy moly.
About 1% of the ones filed actually proceeded to a jury trial.
That's pretty crazy. I never thought it would be that low.
Isn't it? That's crazy, right?
I thought it would be maybe 8 or 10,000, maybe.
Yeah, no,
somewhere in that range.
Very, very low, and that tells you how many people actually do plea, and that's why. I mean, you want the plea, so it guarantees a conviction for the Commonwealth. And so they're paying essentially for a criminal activity.
So to play devil's advocate, and again, I know Wendy does too. She's got tons of friends that are law enforcement. I do as well. I think that they probably would say a lot of times you have a plea because the person that they've fingered for something have some feeling of guilt as well. And I think that obviously we can't speak to any individual cases, but a lot of times the plea occurs because they know that there's something there.
Yeah.
Yeah.
There's some merit to what the police are saying.
Right. And I think again, we want to make sure too that people recognize that we're not saying that police are out there trying to put charges on people that don't apply or anything like that. We're just talking about what your rights are as a human being in this country to make sure that you're well represented in whatever may be happening to you.
Just know your rights, for goodness sake, right?
Yeah.
That's all. And if you are faced with a criminal charge, thank goodness you have that opportunity to go to jury trial.
Yeah.
We have that fundamental right to proceed to trial.
Absolutely.
But in the meantime, if you have a good attorney and they're good at narrowing down your charges for the courts and with the DA, a plea is probably the best route for you if you have any criminal culpability at all. Yeah,
for sure. We got about 15 minutes left. If you're just joining us, you are listening to What's on Your Mind with Wendy and Josh. Or no, it's not What's on Your mind. We just did What's on Your mind. It's a couple of things with Wendy and Josh. Our monthly show with Wendy O'Brien from Proden & O'Brien. Wendy, if people want to get in touch with you, if they need legal advice, how do they do that?
Give us a call at 724-437-3484. We're located 2 buildings before the courthouse on Main Street, 99 East Main. We have a website, prodenlaw.com. We also have a Facebook page. You can reach out to us on any of those.
And you can even put a message in after this video on WMBS's Facebook page too. And you can get in touch with me. I'll get you in touch with Wendy if you need to. But this is the part I've been most excited about. This section called True Crime versus Real Courtrooms.
Yeah.
So what TV gets wrong? Tell me all about it.
All right. So obviously, we love true crime. And the reason we do is because it's entertaining. And even though there's some truth behind, some of those stories, they're definitely dramatized for us.
Absolutely.
For our enjoyment.
Right.
Our personal enjoyment. So I guess, when you watch these Law and Order shows or these CSI shows, you have to look at it in the aspect that these are not real people. These are people that have been selected, and their scripts are very carefully narrated. And often you don't have those type of people in real life.
Right.
They are not scripted, obviously. You are not holding auditions for witnesses in your criminal cases. And this holds true for the police, too.
Right.
Oftentimes they have to file charges for criminals that were violated in some way by another criminal. It doesn't make the charge any less important because everybody has rights. So, for example, let's say, there's a drug dealer that gets shot by another drug dealer. They still have rights.
Right.
They should never have been shot. We don't
Correct.
shoot people.
Right, exactly.
You know what I mean? Just because they are who they are.
Right.
But that's a very difficult case for the Commonwealth. Our jurors do not like defending criminals as victims.
But they need, jurors need to put all that aside.
Yeah,
they're still human beings.
They take an oath. And I've often as a DA, I often reminded my jurors, do you remember that oath you took when you walked in here? That you will look at this blindly.
Right.
We have another human being, no matter what their background is, has been a victim of a criminal offense.
Right.
And that's why you're here.
Right, exactly.
It's another human being. But that is a true real life obstacle for the Commonwealth.
Right. Two of the things that you say what TV gets wrong I really like. One is forensic evidence is not magic.
Yeah.
I love that.
Yes.
And we talked about that a little bit earlier too. I mean, DNA evidence is really cool.
It is.
And it does get used locally.
Oh, it does, yes.
But it's not magic.
It isn't magic. And it's not the end all be all. But And a lot of times it just leads down, a road where it didn't actually lead to anything. Maybe it ruled something out, but didn't really point to the offender. I think we talked before about a DNA test in a rape case we had, where our DNA analyst couldn't read it because the restrictions for the Pennsylvania State Police were so severe. Yeah. But the defense counsel sent it out to another firm.
That's right.
Remember that?
That's right.
And this other firm didn't have the restrictions of the state police.
Right.
And this other firm was able to determine that this DNA did not match the defendant.
Yeah.
So we dropped those charges.
Yeah.
But we were restricted, even though we had DNA, and we could see that it, maybe it could have been a match. I don't know. But we were proceeding with, a charge. We did drop it once we got the actual DNA.
Right.
So just because there is DNA or some kind of
forensic
evidence,
right,
it doesn't make your case stronger.
Right.
It actually could cause a lot of issues and confusion.
And it ties into the next bullet point that I circled. Juries focus heavily on credibility, not science. Yeah. So on TV, they get that wrong.
They do, yeah.
Tell me about that.
So I think my experience in the last, oh my gosh, how many years I've been an attorney with jurors.
Just a couple, right? No.
Jurors, they will judge people immediately. They judge the attorneys. They judge the judge.
They're looking how they're walking, how they're talking, what they're dressed like.
Yeah, how I wear my hair that day.
Right.
I mean, it's head to toe.
Yep.
How you talk to the other attorney, they are immediately judging you. And that's because credibility is so important to these jurors. They're observing you.
Yep.
They are sitting there. They are a captive audience, and they are watching everything you do. I don't know that they're always listening to what is happening on the stand, especially when these boring scientists get on. I almost said a bad word.
I know. I heard it. It was right there. And I knew what you were going to say, and I hear you.
Scientists get on the stand, and they get lost. And
it's 2 hours of testimony that is really not edible by the common consumer.
In 30 seconds, tell me, does the DNA match or not?
Right.
That's all I need to know.
Yep.
But it takes 2 hours to get to that point
yes.
to be able to give that opinion. And there's legal reasons for that. We're not
sure.
just doing
You're crossing your T's and dotting your I's, but
the court requires us to do that. But Yeah, they're not listening. They tone that out. And
Yes.
they're definitely focusing on what is your client doing sitting at the table.
Right. Where are they looking?
Yeah, what are the tattoos on their face?
Right. Are they jiggling their foot? Are they not looking at the alleged victim?
Are they sleeping? I mean, I've had defendants in trial actually put their head down and snore during the trial. I mean, that's,
It's a shame because who knows why they are that tired too.
Often the juror. I mean, usually a defendant doesn't take the stand.
Yeah.
I mean, sometimes they do, but usually they don't take a stand. They don't have to take the stand.
Yeah.
They have a right not to testify because it is not their burden. But those jurors are judging them
the whole
and
time.
their credibility the whole time they're sitting there.
Yeah, absolutely.
And that's significant.
Yeah.
Because you don't. I mean, in these courtroom dramas,
Yes.
they're hanging on every evidential.
Right, but
word.
they're not. Not in real life.
In real life, absolutely.
So I've gotten to be on a couple juries. I was actually a jury foreman on one out in Washington County. It was a 3-day trial, and I really enjoyed it.
Yeah.
So I was, because you and I are nerds, I was hanging on every word. I'm like,
Yeah, taking notes.
Yeah, exactly. I was, I had a really good time doing it, but that is not necessarily the norm. They're paying attention some of the time.
Yeah. and I do think it's, if you ever get called for jury duty, and I'm sure most of our listeners have either done it or know somebody that have done jury duty, they'll know that, it's your job to determine what the facts are.
Yeah. Take it seriously. These people's lives rest in your hands. Again, the case that I dealt with was an assault. It was a significant assault case. But you have to make sure that the case is made, that it really happened.
Yeah. And listen carefully to the facts. But at the same time, I don't think there's anything wrong with judging the credibility of the witnesses.
That's part of your life. That's part of what we do as human beings.
Yeah.
So.
But it's very possible that the Commonwealth has a good attorney and the defendant has a not so good attorney. And it's a shame that they would get punished just because of that.
Right.
And there's actually a jury instruction that the court gives to the jurors before they deliberate that says, and maybe you remember this, don't judge based on what the attorneys tell you.
Correct.
You have to judge it based
They're
on
just
facts.
trying to sway your brain a little bit, but you're going by the actual things that were presented to you.
It's something like don't vote or on what attorney you like better.
Yeah, no, I agree. And so in the case that I had out there where I was the jury foreman, I definitely liked the prosecutor for the county much better.
Yeah.
But they did not make the case.
Yeah.
And I had to vote that way because it wasn't made. And again, I walked away from that. I'm 90% sure that the person that they had on trial had something to do with something.
Oh, sure.
But their case wasn't made for the things that they were trying to say that person did. He may have done it. I don't know. But because I didn't know, I had to know.
Yeah, and that's reasonable doubt. You had what's called reasonable doubt.
Right.
And that reasonable doubt has to be determined in favor of the defendant. It's a not guilty verdict.
That's what we had to do.
Yeah.
So I remember it very well. So PA reality, we'd say most cases are resolved pre-trial.
Which we talked about.
We did talk about
I
that.
have the Fayette County statistics
Okay.
too, because I think that's interesting. I thought it would be higher than this too. It's higher than the statewide.
Okay.
Looks like, let's see here. Where did I put that? Fayette County. Okay, so in 2024 in Fayette County, we charged 2,312 new criminal cases in 2024.
Okay.
Which is a lot for
That is a
county.
lot.
And again, those are felony misdemeanors.
So the bigger ones.
Yeah. The actual trials that were completed in 2024 were 55 cases.
55.
Yeah, so that's about 2.1%.
So it's almost double the percentage.
Yeah. So it's higher than the statewide average.
It's still not a ton, though.
Still less than I expected. We do a lot of trials here. I know that from work, like being on defense boards and on the District Attorney Association. We do more trials than most counties per capita.
So talk to me about this one. PA reality versus true crime. Motions matter more than dramatic testimony.
Yeah.
Tell me what you mean.
So when a lot of the cases are resolved pre-trial, obviously, because they're not you see the statistics here. 1% actually go to jury trial. And those involve motions, pre-trial motions. And those include various reasons why the cases should be dismissed. And a lot of good criminal attorneys can win and beat criminal charges pre-trial motions.
Wow.
And those, that basically gets these higher charges that shouldn't have been charged to begin with thrown out because the evidence isn't there to continue to hold it for a jury trial.
I gotcha.
Or, there's often witnesses go away or disappear too.
Yeah.
I think of your normal assault case. It's probably a boyfriend, girlfriend, could be.
Yeah, and they may decide not to.
Yes.
Yeah.
We used to call that the letter we would require the victim to sign off on if they didn't want to proceed with the criminal charges. We call those love letters.
Well,
give them a love letter.
Obviously, that's what it is.
Because it's,
they're letting them go.
In the heat of the moment, they're calling 911. The police are coming. And someone's getting arrested. But it doesn't mean that goes on forever.
Right,
and
exactly.
By the time you get to court a year later, these people don't want to proceed. So a pretrial motion to dismiss can be filed. Those are called omnibus pretrial motions. And if the witness doesn't come and then doesn't, support the evidence, the judge has to throw it out.
Right. This last note before we hit the summary, too, is very Wendy-esque. It says real cases are won quietly long before anyone ever sees a jury.
Yeah.
And that's kind of ties into what you just said about motions and stuff. But I also think that it ties in, like you said, too, people deciding I'm not going to testify.
Yeah.
All these steps that go into it.
Or even the case I talked about, the rape case. I mean, that DNA evidence, even though our state police lab couldn't determine for sure it was the defendant, another one did. So often evidence develops in a case over time that we didn't have up front.
Yeah.
And it can develop to prove somebody innocent.
Right.
I mean, unfortunately, defense and defendants do not have an obligation to prove themselves innocent. But there are cases where they can do that.
Right.
And that's a lot of reason why these cases go away after a while.
Yeah. So we've got just over 2 minutes left. I'm going to let you do our summary. I know it flew today.
Holy
so
cow.
give us our summary because we can get to our favorite segment for the last minute.
All right, summary. Know your rights in Pennsylvania about it's not about avoiding responsibility. It's about protecting yourself in a system that moves fast and doesn't pause for misunderstandings.
Yes.
So the police aren't going to stop because you don't understand something. The judge doesn't care if you don't understand the law. You need an attorney to navigate you through this very complicated and quick system.
Right.
To be successful, to make sure your rights are fully enforced.
Right.
Empower yourselves. Get an attorney.
Get an attorney.
And if you can't afford one, the court can appoint you one. Our public defender's office is full of very qualified attorneys. And then we also have conflicts counsel. If they can't handle it, the county has conflicts attorneys too that handle your cases. And they are all extremely qualified. They're in court very frequently. They're not a free attorney and don't know what they're doing. They know what they're doing.
Right.
They're great.
Yeah. And don't rely on TV and Google for legal education.
Oh my gosh, please don't Google. Don't Google.
Don't Google. Don't Google. All right, we got 1 minute.
ChatGPT is not your attorney.
Right. Don't go to AI. So new year, new you?
Yes. So remember, get your wills and estates and your affairs.
We talk about it almost every show.
Every show. It's so easy to do. Get it done. And not what a better time. You're going to get yourself healthy, get your legal or stuff organized, and get your wills and your estates and your estate planning all done.
Right.
Come see us. We can help you with that.
Right. So Steelers playoffs, do you want to predict the...
Oh, I'm predicting a win. We are going to take this. We're going to go all the way.
I love it. That's what we like to hear.
Yes.
And winter sports, assuming the risk, Wendy reminds you to...
Yes, assume the risk. Be safe. Know if you're signing waivers, you're waiving everything.
Right.
So read it.
Right.
Understand what you're signing.
Have fun, but be safe.
Oh my gosh, have fun. Enjoy this weather. I know it's a little warm right now, but boy, did we get some snow for our skiers. And
we definitely did.
Yeah, it's hockey season for me too. So
That's
I
right.
love hockey season.
It's been a great show. Thanks again, Wendy.
I can't believe how fast that was.
I know, super fast. We'll throw it back to you, TJ. This has been A Couple of Things with Wendy and Josh.
Bye-bye.
And this is WMBS Uniontown at 4 o'clock.
Is CBS News on the Hour, sponsored by Pfizer.
I'm Jennifer